Under due process clause of the Constitution than that which requires notice and opportunity to be heard before any person can be lawfully deprived of his right to be heard before any person can be lawfully deprived of his rights. Indeed, when the Constitution that no person means that every person shall be afforded the essential element of notice of any proceedings, any act committed in violation of due process may be declared null and void, Your Honor.
Is it the position of the defense counsel that indeed there is no probable cause in this case?
That is our position, Your Honor. And if we were allowed during the early days before the evidence of the reception in chief, Your Honor, we would have done so right at that moment. We seem to be faulted.
But you see, under our rules of impeachment in this Senate, we do not have a provision governing preliminary hearing on defenses in impeachment cases.
Yeah, but that was...
And we devised by the Constitution that the Supreme Court can formulate for this House. It is the formulation of this House itself.
That it is available in all kinds of proceedings, including impeachment proceedings.
Determination of probable cause be done by the House of Representatives, or could it be done by this Court?
It may be done, Your Honor, by the House of Representatives, and any ruling by the House of Representatives may be brought before the Senate Impeachment Court if the opportunity so arises. And a ruling thereon may be made, either a denial or a grant, Your Honor, in which case judicial remedies are afforded in favor of the aggrieved party if there is an abuse of discretion that brings about the power of judicial review on the part of the Honorable Supreme Court, Your Honor.
The Majority Floor Leader.
Yes, may we recognize Senator Miriam Defensor Santiago, Mr. President.
The gentle lady from Iloilo.
Mr. President, may I offer the humble submission that in my view there is no constitutional issue involved. There is no constitutional issue of due process or equal protection. Instead, there is a specific rule in our rules of court, Rule 16, Section 6, which is entitled Pleading Grounds as Affirmative Defenses, and it quotes in part, if no motion to dismiss has been filed, any of the grounds for dismissal provided for in this rule may be pleaded as an affirmative defense in the answer, and in the discretion of the court. I would like to emphasize this phrase. In the discretion of the court, a preliminary hearing may be had thereon as if a motion to dismiss has been filed. The annotations based on jurisprudence indicate that unlike a motion to dismiss based on the failure of the complaint to state a cause of action, which may be resolved solely on the basis of the allegations of the complaint, a motion to dismiss raising an affirmative defense that there is no cause of action as against the defendants poses a question of fact that should be resolved after due hearing. Therefore, the issue is really whether the defense is there is no cause of action as against the defendants, and the question is a question of fact. Then, in that case, a hearing in the proper discretion of the court might be ordered, but otherwise, it is completely discretionary with the court. A party effectively submits to trial court's jurisdiction by praying for the dismissal of the complaint on grounds other than lack of jurisdiction. So, just to repeat to summarize, granting a hearing on a ground alleged as an affirmative defense is, as the rules say, in the discretion of the court. That is my comment.
Counsel, you are not questioning the jurisdiction of this court.
If there is really no probable cause, Your Honor, and therefore the impeachment complaint is a total nullity, then there could be no jurisdiction that the Senate Impeachment Committee can acquire, Your Honor.
If the issue of probable cause could be decided on the prosecution side as well as in the court itself, This is my understanding of the rule in the ordinary courts, in criminal cases.
We appear to be quite insistent on this particular matter, Your Honor, because we have sought guidance from the jurisprudence of the Honorable Supreme Court in connection with this matter. More particularly, whether probable cause could be raised even after the remand of the impeachment case to this Honorable Supreme Court.
In the case of Francisco, the articles of impeachment has not reached this court. The case arose out of the proceedings in the House of Representatives, and so therefore the Francisco case is not on all fours with respect to the factual situation in this particular impeachment.
That's correct,
proceeding.
Your Honor. But it is a guidance, since there is no categorical provision under the rules of impeachment of the Senate Impeachment Committee. Many times we are at a loss, Your Honor. Here is a problem. We wanted to argue either against or for, but there is no definite provision under the rules of the Senate, Your Honor. So where do we go?
Do you know why it is like that, Your Honor? Because there is no appeal in the decision of this. There are no assignment of error once or conviction. If it's acquittal, the government cannot appeal. If it is conviction, the respondent cannot appeal. There are no assignment of errors. There are no reversible errors. So that is the reason why in an impeachment trial, as far as I know, there is no motion to dismiss. There are no motions for preliminary hearings. That's why the Constitution says trial shall forthwith proceed. It did not say begin. Proceed. Go ahead and try it, and all the way to judgment. Except that you have to respect the rights of private parties that may be involved.
Well, we were this insistent, Your Honor, because we are worried about the resulting consequences of the aforesaid pronouncement, Your Honor, with due respect to the Honorable Court, on the impeached public official, Your Honor.
All right.
We have here a portion, Your Honor, and before we are considered terminated in our argument, Your Honor, may we read it for the record, Your Honor.
We will understand your position. If you want to read your argument, go ahead.
The question on the sufficiency of the complaint in form may again be brought to the Senate by way of proper motion, and the Senate may deny the motion to dismiss the complaint depending on the merits of the ground raised. After the Senate shall have acted in due course, its disposition of the case may be elevated to this court pursuant to its judicial power of review. So we are referring to a situation where an apparent grave abuse of discretion existed on the part of the impeachment court.
What this court wishes to avoid is a clash between the Supreme Court and this court. Because, frankly, I must say that this court is not willing to surrender its power to make a judgment in impeachment cases. And so, if the decision of this court with respect to the existence of probable cause is reviewable by the Supreme Court, then, in the opinion of this presiding officer, and I think as well as of this court, that will mean that the Supreme Court will override the judgment of this impeachment court. And so therefore, with most regret and with due respect to the Supreme Court, we will deny any interference in the judgment of this impeachment court.
Mr. President.
Well,
trial suspended. I will consult the members of the court.
Thank you, Your Honor.